You are listening to the Julie Parker Practice Success Podcast, where you discover management insights and strategies for your successful dental practice. There are also interviews with key people in the industry who have advice and services to help you and your team achieve great success. Welcome to this week's episode of the Julie Parker Practice Success Podcast. And we have brought back Burke and Associates Lawyers again today because there have been a couple of court cases that I think many practices will be very interested in. And we're furthering our discussion around how are we going to set up a relationship with our, kind of in inverted commas, employee dentists. Are they going to be under contract as an employee, as a contractor, as the, service and facilities or service and licenses agreement? So there's been some updates around that. And we've got Special Counsel to Burke and Associates Lawyers, Elizabeth Ong, joining us today, and I'm so thrilled to have her here. Elizabeth has had over 20 years of legal experience, has practiced both here and in Malaysia, and speaks a whopping 6 languages. And so hopefully we can just stick to English today because I can only speak the one. But Liz, welcome to the podcast. So great to have you here.
Thank you, Julie. Thank you so much for the kind introduction.
Oh, that is my pleasure. I'm thrilled to have you here. This is a topic that myself and my younger sister, who is a bookkeeper to dental practices, we talk about this all the time because there doesn't seem to be a happy resolution around this particular issue. Now, you recently presented to a group of dental practice managers on a couple of court cases that have gone through and provided a little bit more insight around the situation. But to further explain it a little bit to our audience out there, what are the differences between the different working relationships we can develop with our kind of associate or employee dentists?
All right. So thank you again, Julie. So I think I would just begin with recapping what has happened. And I think the first thing was my partner, that's Meghan, she has obviously spoken about these rules and regulations and guidelines in this space. And Julie, I think you were very spot on. You touched on key points that were relevant in terms of what happens to the business, goodwill of the business, and what have we got to do with restraint. So I think you have dealt with already in the previous chapter, but I just want to say that restraint was one of the things that the courts consider in one of the cases. So it's very relevant. People need to know, medical practitioners, dentists all have to know that what can you do if you want to include a restraint clause in the contract. And I'll touch on that when we get there. So, Julie, just as a mere introduction as well. It's always changing, and I think it's good that we are constantly changing. We have to be aware of what are the changes, how the court thinks, so that we can get the relationship right. I think it's important to note as well the agreement will be the agreement. It's always the substance of the agreement that we're looking at. So you can call it facilities and services agreement, you can call it service and license agreement, you can call it service agreement. That's just the form. And we need to know the substance. And where do we find the substance? That's from the courts, obviously. And, it's good that we know, I'll take you through the updates and so that you're aware what the court is looking at to say that this is an employment or is an independent contractor relationship. So
great. Because just to jump in very quickly, Liz, just to continue to bring our audience back in the headspace that we're in, because traditionally, back in the years that I was a dental practice employee and then owner, and I sold my practice in 2013, casting my memory back, and there was always the common way of employing a dentist was that the dentist was treated as an employee but paid as a contractor. And everyone kind of thought they were doing the right thing, but they were never really doing the right thing. But it was kind of the accepted norm. Over the last number of years, especially with the explosion of Facebook, and there's been a lot more discussion amongst employee dentists and employer dentists as well around this area. So there's been a lot more awareness, but also the larger corporate entities of practice ownership, they're really having to make sure that they have what they've got in place is absolutely legal, like we all do, but because these are larger organisations, they're the ones that have been able to have the funds to really get proper documentation and contract work done by lawyers behind the scenes. And it is an interesting area because everyone's understood the way it used to be, although it wasn't totally accurate the way it was done before. And so there's a new awareness being awakened. And so the broad framework is that if you are employing a dentist as an employee, then you need to put them on an hourly rate, get sick pay and minimum rate and all these things. And they are entitled to all the things that every other employee in your practice, such as the receptionist and dental assistant, are due. And that's a very difficult thing to calculate when we're talking about giving them the equivalent of what their commission base would be, but setting in place a minimum award rate or a minimum hourly rate that they would be paid if they were sick or on holidays or what have you. There's a lot of complexity around that. And my younger sister and I, Jenny, we set up this beautiful Excel document with all these formulas, and we feel like we hit the nail on the head. But getting people to understand how to use that was quite complex. And it's quite a step away for these employee dentists to understand that by the end of an employment year, you'll have the same financial benefit. It's just broken up in different ways. However, on the flip side, if we're getting people in as contractors, that means that they really have to wear their own uniform and they don't have to comply to your policies and procedures. They can, at the drop of a hat say, I'm not coming in next week, by the way. And so they really end up being like a visiting accountant that comes on site. And that's a proper contract arrangement too. Neither way suits both parties in the same way, and this is where these service and license agreements or service and facilities agreements, this is where they've come into play, and this is what the courts are now and you are now dealing with on a regular basis. Would that be a good little summary?
Yes, that was perfect. That was really good. So what you have alluded just now, it is very clear that you are either in an employment relationship or you're in a contractor relationship. So I think the courts have distinguished that, because if you are in an employment relationship, you want to hire the dentist as employees, so you have to pay, so you'll be liable to pay for the employees' entitlements, payroll tax, super. So what people are trying to do is medical practices, host practices, they don't want to pay for this. So the dentists are then coming in as independent contractors. And even having said that, it's not just the agreement that says that, you are an independent contractor, you don't wear the uniform, you have control over your work. It's not as simple as that. It has always been a tricky area. And I think our job is to educate people to be aware of how they can structure. Be smart about it. Like, if you know, you're going to do it right. And when it's right, you're not afraid of audits or whatever challenges, court claims. You're kind of protected, although we know we cannot eliminate all risks. But it's better than nothing. So it's only when you don't know what you don't know, that's very, very dangerous. And people have to know what we can tell them. And it's a matter of us telling them. And it's good that you touch on the fact that, so they, like the example that you gave, that the dentists, they were employees in a sense, and then they're contractors on the other hand. This one is the thing that the courts don't like now. They don't like to see a mixed in that kind of capacity in a dentist himself or herself. The other thing that they don't like is, let's say you've got 10 dentists, you've got maybe 5 of them as employees, and 5 as contractors. So if you have a mixed relationship in the practice itself, what we think will likely to happen is that the courts will say that they are all employees. I don't care about the contractors. They will like to deem that all of them would be treated as employees. And that's why we always...
So if you've got 10, sorry to interrupt, if you've got 10 dentists working, if I'm the employer, if I'm the practice owner, not the employer, if I'm the practice owner, and I've got 5 dentists on board and I've employed them as employees, so they get a baseline hourly rate that gets increased if they earn over a certain amount of money, and they start getting a percentage of what their earnings are instead, but there is always that they are treated as an employee. And then I've also got other dentists on board, maybe another 5 of them, and I've actually got them as a contractor arrangement. And I comply with the contractor arrangement with them. Do the courts not even like that arrangement?
No, generally no. It just depends. Well, I must qualify myself. We have seen the pattern where courts will say that either you are the whole independent contractors relationship or an employees. So when you mix relationship, we always tell our clients that it's really not advisable, because the tendency is that the courts will interpret all of them, even the contractors, to be employees. So
that's amazing. So you've really got to make that decision as a practice.
Yes.
This is the way this is the one single way that we're going to be employing our dentists or getting dentists to work in this location.
Yeah, but based on our experience, I mean, we've got clients coming to tell us, like, look, I've been with the dentists, like, few of them have been with us for many, many years. They started off being employees, like, in the 80s or 90s, wherever. They want to maintain and retain as employees. And it's hard because then the new dentists that are coming in, they are contractors. So we have been challenged by this scenario, and we advise our client, look, we understand why the older dentists remain as employees, because you have started in that manner with them, and they want to keep that relationship because some of them just want to take leave, just come and work, and then they have a lot of factors why they want to do it. But we will always tell the medical practice, say, look, medical center, try the dentist practice, saying that try to keep them all on the same footing. So either it's black or white. This is like black and white, so it becomes gray, which the court is like, nah, it's white or black. So in a way, we know that there are challenges. We know that some people, the other thing about, you want to keep the dentists as employees would be, let's say you want to retain them because they are good in their intellectual properties, and you want to keep those qualities that they have, they remain as employees because you control them. But if you're the independent contractor, you can't control them and you cannot own what they have. Employee, yes, you can. So there is a difference in the relationship, and it always depends on what the parties want to achieve. And let's say if you want, we don't want employees relationship because we don't want the risk of being sued. If the dentist, performs a defective service, obviously claims will come. And if he or she is an independent contractor, we can sever the liabilities. So the medical practice, the dental practice is not at risk. The doctor is. So we quarantine it. So that's good to have an independent contractor relationship in that manner. So it's all about what the parties want. There's no right or wrong answer, but I think we are here to talk about if you want to structure it to be independent contractor, look out for these things. Yeah? So I think those are the points that the cases are telling us. And if you miss one of them or two of them, then it's not an independent contractor, then it becomes an employee. And then that's where, you have to pay super, payroll tax, employment entitlements, penalties, interest, back pay, all sorts of money. So,
and that's where we want to mitigate the risk around that, because that's the sort of stuff that keeps people awake at 2:00 in the morning going, I've got to get this sorted. Every month that goes by, I'm getting potentially more in the hole because I haven't managed this situation. Exactly. And so it is something that we do encourage dental practices, get on top of it as soon as possible, because if you think it might be a concern right now, then picture yourself another 5 years down the track, another 5 years worth of pay, holiday pay, sick pay, all of that
Yes.
stuff, and you just want to get it sorted. It will be painful right now, but you want to get it sorted so it's not even more traumatic later on down the track.
Yeah, you don't want to be awake thinking, when am I gonna be audited? Like, who's gonna knock on my door next? It's not Santa, it's not Christmas, but it's just the SRO or ATO that's coming to knock at your door. And this area is so highly scrutinized. Like, it's always audited. Somehow it is just the favorites of the SRO and the ATO. So we just have to be careful. And we always tell our clients, like, if you are prepared, you got the structure right, the foundation is solid, we want to say that it's unshakable in that sense, although, you might be audited and you'll be fine because the contract says that it's an independent contractor's relationship. So I think, that's why we think that, the cases are quite clear now, and we've got two cases that are very interesting. Not that they are any easier to understand, but it is what it is. So it is what it is. And I love the fact that how the courts are so creative in coming up with the decisions. Like, at one point they'll say, oh, that's an independent contractor, but hang on, it's an employee now because of super. It gets a bit convoluted in that sense, but it is what the court has decided, and it is important that audiences today understand what the court is thinking, how you should use those points to put in your structure, and that's where we help to draft and make sure that legally, that's correct. You have done this, and this is what the case has said it to be. So in that way, in a way, you can't be challenged. The court says that, the case law says that, and we are complying 100% with what the case law is saying.
Wonderful. Well, I'm looking forward to this, to you discussing what's happened over the past recent couple of court cases. And this is one of the reasons why, when you mentioned before, this is one of the reasons why it is a big topic that my sister and I talk about all the time, and it keeps rising up because there does seem to be a focus by the State Revenue Office and the Australian Taxation Office on this space. So it's not like it's an area that's always washed over and semi-ignored by the governing bodies. It is something that is catching people out because they've got a focus area on that. Okay, so tell us about these couple of court cases that have gone through and these creative judgments that have come up in those court cases.
Yep, definitely. So I think there are two cases, and they're pretty recent. So the first one will be Dental Corporation against, that is 2020, and there's a full court of Federal Court of Australia. And this is the one that's really relevant to dentists. And it is a case where the court has decided it is not an employee, but it is also an employee. So this case has been decided in a way where the courts held that the dentist was an employee for purposes of the Superannuation Guarantee Administration Act 1992, and that's where the dentist was entitled to the superannuation contributions. Okay, let me just explain the facts, and then we will go to the key points that the courts have decided. And the key points are the things that we will always tell our clients to look at. And this is the fundamental thing that the medical practice has to know, how to structure their relationship so that they're not going to be exposed like how this dental corporation is exposed.
Right.
So history teaches us. It's a good teacher. It teaches us what we should do and what we should not do. All right. So the decision by by the full court of this case has highlighted again the potential risk which a host practice, dental practice, may be exposed to if the independent contractor arrangement with the dental practice is not set up correctly by the parties in the services and license agreement. So the facts were very simple, and I think that any dentist who hears this podcast would know, oh, that sounds like me, like my relationship.
Yeah.
So it's very applicable, it's very alive, it's very real. So facts. Dr. was a dentist who had been engaged by Dental Corporation as an independent contractor. So they had this thing called services agreement between them, and that was terminated in November 2014. And guess what? Dr. was not happy. He brought proceedings, in the federal court, alleging that he was an employee. So he wanted to be entitled to be paid accrued annual leave, long service leave, and superannuation. That's normal. If you are an employee, you should be entitled to all these benefits anyway. So the trial judge held that he was not an employee at common law. So, and hence, he's an independent contractor. And rejected his claim, and Dr. then appealed. So we will pause here for a moment and think, why did the courts decide that he was not an employee? They said he was not an employee because he could work as much or as little and take as many holidays as he wanted. So he controlled his own working schedule. So he's an independent contractor. I think we touched on the employment setting where there's this checklist that Meghan explained. If you control how the dentist takes leave, you are exposing yourself, opening up a can of worms to say that he is an employee, the dentist is an employee. So this is a very good factual key point that the courts have said. If he could take as many holidays or how he works, he's an independent contractor. And the second thing, how they've decided that Dr. was an independent contractor was he was underwriting the cash flow of dental corporation, because he had agreed to compensate dental corporation if the annual cash flow of the practice failed to reach a particular level. So if you have a dentist that comes in and say that, I'll make sure that the dental practice is earning that much and I will underwrite, if it doesn't happen, it's an independent contractor situation, which is good in a way. However, the trial judge held that he was an employee for the purposes of superannuation contributions. We have just said that the courts held him to be an independent contractor. How can the courts now say that he's an employee? That's oxymoron. On one hand, you're saying that you're an independent contractor. On the other hand, you're saying he's an employee. So it is interesting. And how the courts have decided that he was an employee is because they said that under the terms of the services agreement, Dr. was required to provide dentistry services to patients of the practice and practice management to dental corporation. Yes, you're providing the services to the patients, but they are saying, in a way, you're providing services to the dentist practice, because you're also providing practice management services.
So the provision of practice management services quite separate from the clinical delivery of dentistry?
Yep.
What are they deemed as the practice management services? What came under that banner? Do you know?
I think it was, so what he did was, let me see, the practice management that he did, if I'm not mistaken, when requested by the dental practice, he would provide guidance on how the dental practice should provide administrative services. The dentist, Dr. was also required to determine appropriate fees and maintain patient records. He was required to do all of these things personally, but had the option of procuring other people engaged by the dental practice. So I think that was the practice management, like he was guiding the dental practice on fees to charge, on providing the correct administrative services. I think that those were the kind of.
So under traditional employee dentist or contractor dentist arrangements, it's just the provision of dental services. And it was that additional practice management coaching training that he was providing dental corporation that deemed him by the trial judge as an employee in that section of his activity, therefore due superannuation.
That's right. So it must be always clear in the agreement that the dentist is only providing services to the patients, not the the dentist dental practice, never to the dental practice. And it must always be clear as well is the dental practice is providing the services to the doctor by providing the facilities, the rooms, the facilities, the reception, the support staff, booking, that kind of stuff. So it's the other way around. So this one here, the moment that's why I say it's also very factual, because in this case we can see that he was providing services to the dental practice, which then led to the court saying that, look, it's not, forget about the employee part, forget about the independent contractor part. The moment you're providing services to the dental practice, that is an employment relationship. You're an employee providing services. So they call it's quite technical. They said he was an employee for the purposes of the Act, the Super Guarantee Annuation Act, as the services agreement was wholly or substantially for Dr. labor. Those were the words they used. So he was providing his labor to the practice, dental practice. So we encourage dental practice to make sure the dentist is not providing services to you, the other way around.
It's just clinical provision of dental services to patients, and that's it. So in that particular case, if there wasn't any of that dental practice management assistance that he was providing, then him being deemed as an employee yet, or I know we can't say for sure, but that wouldn't have been an issue. He would have just been deemed as an independent contractor.
Absolutely correct. I think if, let's say, we didn't have that point, maybe the case would have been different. So I think that's the distinguishing point that people have to be made aware of, and the fact that, if you want the dentist to provide services, it must always to be the patients only, not to the dental practice. I think that's rule number one in this case.
Mm-hmm. Interesting. Is there differences between if a case was brought against a dental practice by an independent contractor dentist saying I'd like to be deemed as an employee, or I feel like I was treated as an employee, so I should get the benefits and entitlements that I'm owed? Does that go to a state level court system first, and then if it's on appeal it goes higher? What are the stages of that?
That's a good question, because I think, yes, it goes on the, I don't practice in the litigation side of things, but I think, you've got a hierarchy of court system that goes. In this case, so they can still appeal to the High Court. It was just a full court. So what happened was Dental Corporation made an unsuccessful application in the High Court for special leave to appeal. This means that the finding that Dr. is covered by the Super Guarantee System stands. Nothing changes because Dental Corporation was unsuccessful in the appeal. However, given that the enforcement of the Super Guarantee System lies with the Australian Taxation Office, ATO, probably we will have to wait and see whether the ATO will use the decision to review similar arrangements, particularly in the allied health sector. So it's interesting. I think the court system fully exhausted, but the ATO still can regulate, and they still can review and say that this is the correct arrangement or this is not the correct arrangement.
This is a lovely example of using these sort of court decisions to direct how we change and manage working relationships now. Yeah.
Exactly. So that's why I say it's very important that we look at the case laws, understand them, digest them, see what is that distinguishing factor that the court is looking at. And if you have similar facts like this, you must ensure that don't do it. Or if you want it, just do it. It depends on if you want an employment arrangement, do it. If you don't want, because we're talking about, that's a lot of money. It wasn't reported how much Super Guarantee Dr. got. We don't know what's the quantum, but I'm sure it's nothing cheap.
For sure. And this is, as we said before, we don't, the longer that we are in a relationship that, a business relationship that, or an agreement that we are not fully complying to, the longer that goes on, just the larger that sum of money becomes, if it got to the point of legalities later on.
Yeah, that's
so there was
true.
a second case you were talking about as well.
Yep, the second case would be, this is a New South Wales case, but why it is so important for us, it follows a Victorian case. So we have a Victorian case that's called Commissioner of State Revenue versus the Optical Superstore Private Limited that was decided in 2019. So that decision was the first decision on payroll tax, which the courts held that obviously that was a case on optometrist. Well, it's still medical and health industry, regardless of whether you are an optometrist or you are a doctor, you're a dentist. They all fall under the same umbrella of medical and health industry. And if we see that this is how the court would decide in one case dealing with optometrists, medical officers, we call them, it would probably be the same, most likely would be the same treatment for dentists, doctors, GPs, whatever, surgeons. So this was the first case, and they held, the courts in this case, the optical superstore, we call it, they said that the optometrists were subject to payroll tax. So, and this was further adopted by this recent case that I'm going to present on, and take note of the key points, how the courts have decided again in this case that would determine whether the relationship is independent contractor or employee relationship. So the name of the case is Thomas and Nash versus Chief Commissioner of State Revenue 2021. So this case is a very recent decision coming out of the New South Wales Civil and Administrative Tribunal. So it's like our VCAT. So if VCAT, that's the lowest, it can still be appealed, and you can still go up the hierarchy of the court system, yeah? But we haven't seen any appeal yet. I think from my last checking, if I'm not mistaken, the time to appeal should have lapsed by now. So, which means that the case will stay. The decision of the case will be the case binding on matters that are similar to the facts of this case. So, let me start with the facts. So this one is on not dentists, doctors, medical centers, but still very relevant because, well, the behavior of the courts in this case has not changed. They are still very, how would I say, they are very, not rigid, they are very strict on calling that relationship an employment relationship or an independent contractors relationship. So it's clear-cut that this case was subject to payroll tax, obviously, and they're saying that these doctors are actually employees. They're not independent contractors. But the terms of the agreement, they were drafted in a way where it was supposed to be an independent contractors agreement. So what has gone wrong? Let's look at the case. Probably not wrong. It's just how creative the interpretation is. Cool. So the facts. Thomas and Nash, the owners of the medical center, they own and operated a number of medical center locations. Very common. The terms of the agreement in place between the medical center and the doctors were as follows. And we call these the 7 key points that the courts have used to determine what they have determined to be the decision that they made. So first one, they said that it was quite clear in the agreement the doctors were to provide services on a 5-day per week basis, including weekend rotation, and in this regard, they agreed to meet roster commitments and to provide advance notice of planned vacations, which were limited to 4 in a 12-month period and which had to be approved by the medical center. I think this one would flag some red flags. Yeah. So it will. If you're planning to have your dentist working on a 5-day week basis, on a roster commitment, and also plan vacations and you want to control, they have to get your approval for leave. Be careful.
Yeah, and it needs to be the 4 weeks. It can't be, 12 weeks of holidays that you take. This is the case in many, many dental practices.
Yes.
Regardless of what agreement that employee is under, that's kind of the expectation for sure.
Exactly. And this is a very hard one because I've got a client coming and say, my dental practice, there are 3 females. I'm the only male. The females love to take leave and I don't have anyone working with me. I'm like, okay, so what do you want to do? And he was like, can we put a provision saying that, the dentist should have minimum service hours? I said, you can't do that. If you're going to do that, you're going to inject the element of control, which the court never likes. So if they are independent, that's the literal, if they're independent, they can do what they want. They can take as many leaves as possible. They can work on the number of hours that are probably not ideal to you, to the dental practice. Like everyone wants profit. The more you work, the more I get. But just be prudent. You cannot control. I think the whole idea is that you can't control how the dentist operates if you want them to be independent contractor. You cannot fetter their discretion. You can always, but the way to overcome, having said that problem, I think the way to overcome practically, talk to the dentist, talk to them, agree with them what they want to do, balance it. It's always a balancing act. Like, the communication is rule number 1. As long as you have spoken with them, they say, look, I'm comfortable working on this. It's something that's agreed. You're not controlling the dentist, but the dentist have come and said that I want to work these hours, I want to take this leave. And never have to approve their leaves. You can't do that. So I think it's very clear-cut from this case saying that, you cannot have the dentist seeking approval for their leaves.
Yeah. They need to just say, these are the weeks or the days that I won't be working. And their dental practice goes, okay, groovy.
And they have to think about who else can come in or do something about it. I'm sure you can juggle and manage the service hours on a schedule, but never commit them to a roster commitments as well. We have seen that this is a disaster, recipe for disaster.
Yeah. So number 1 is rostering and leave.
Holidays, working hours. Yeah, as long as it touches on controlling them, no go. No.
Great.
Yeah, the second one is they held that the doctors were there to promote the interest and business of the medical center, including not channeling patients away from the medical center. So I think there would be a clause in the agreement that says that you must promote the interest and business of the medical center at all times. And again, this is not ideal. This is just not ideal. The other way to promote the interest of the medical center or dental practice is wearing the uniform. That's a way to promote. And in fact, you're shooting yourself on your own foot because then it's an employee, not an independent contractor. Yeah. So as much as you want the dentist to promote service of the medical center, the dental practice, it's very limited in a way that you can do it. Like marketing stuff, you can't have the name of the dental practice. It must be the doctor's name, for instance, that is marketing it. So that there is, again, element of control by the dentist, not the dental practice.
It's such a mindset shift around it, isn't it? And I think a lot of practices may think, well, we've got the contract, we've got the agreement, everyone's signed down the bottom, that's what mitigates our risk, but indeed not, because these governing bodies then look at what has been evidenced in your past dealings with this person, and that's what deems it to be independent contract or an employment relationship, despite whatever agreement or contract says.
Spot on. That's so clever. So agreement itself is not bulletproof. Yeah, just because you have an agreement doesn't mean that it's going to stay forever. We know that. We need to look at the clauses, and the clauses must be, you must cleverly draft them in a way it speaks in the language that the court wants to see, not just drafting clauses that, yeah, it should be all right, it should be fine. But we have seen so many key points that the courts have told us that you have to have or not to have in your agreement. And that's what we are emphasizing to our clients. We know you have a contract. Some of our clients, they are new practices. That's fine. We all start on a clean slate. So prepare the documents for them. That's easy. It's the existing dental practices, medical practices that come to us as like, look, I already have an agreement in place. I don't think I need your agreement. I'm very sure that was done properly. And my first question is, has it been updated? Has it been updated? Because we need to look again at the clauses. What was cleverly crafted last time might not be clever now. So
and court cases go through that change the landscape.
Exactly. So nothing stays forever. I say good. And some clients are like, oh, I've just gotten this contract done in 2020, 21. I say, look, there's a new case now. And 2020. Yeah, that's all. It's like a fashion. You see this nice dress and the next thing is like, that's not the fashion anymore. It looks similar, but it's not.
Yeah.
So we'll tell our clients, like, that's why we do a health check, legal health check as well, which I think my colleague has mentioned, which is good.
We've always got a link to that legal health check in the show notes of all of the Burke and Associates Lawyers podcast episodes, because that's such a fantastic idea, just to make sure that everything you've got in place is actually servicing you well for the future.
Exactly. What we're trying to do is making sure that, you are protected in the long run. That's what the case is saying now. It has to be updated. And the health check is really a health check. Just like we do a medical checkup to make sure that our body is good every year. It should be annually, which I'm slacking a bit, but never mind.
You're nice and young, fit and healthy.
Not that young, but still not a fun thing to do. But it's supposed to put in place a protection for you to make sure that you're healthy. So we always tell our client, existing businesses, let us have a look at your agreement. We want to make sure the clauses, because they might not be drafted by us, or even if they're drafted by us, we would revisit to make sure that we've captured the points that are that have been decided in the latest case, so that we are up to date. I think it's very important. Up to date is the key. You lose out because you are still in the old system. You're still using the old platform. It's just like the computer. You have to be updated. Your phone has to be updated. You can use an older version, but you're exposed.
Things change, evolve and develop and shift. And so I think we just need to make sure that we're shifting with the changes. Otherwise, that gap between where we are right now and where we should be is bigger and bigger.
Yeah. And the other thing I think I would also, just on this point, I think I would touch about is that they always have to talk to their accountants. Getting the right tax and financial advice is also important, because this case, I'll talk later on, it touches on bank account, like monies received from patients, which we'll see afterwards how that has to be structured. And this is where your accountant will help you to set up so that there is the minimal tax implication on how to do it. We'll talk about that. That's the key point number 5. So we are at key point number 2. We'll go to number 3. Mm-hmm. The courts have also decided in this case that the medical center here, they were able to retain the business records of the business. So what I'm saying here right now is the business records should belong to the dentists. In this case, it's doctors, but I'll just use interchangeably. The business records patients' records, they must always belong to the dentist, not the medical center or the host practice. And this is the tricky part, because you would think that the host practice should have it because of goodwill. But if the moment the host practice, the dental practice or the medical center has possession or control of the business records, the court is saying, no, because you have that control, the dentists are not independent contractors. Either way, it's no good.
Tricky, Liz. It makes it all so tricky.
Yes. Because as an owner, the dental practice, you want to have possession so that goodwill is retained.
And quite often those patient records were kind of under the ownership, if you can own patient records but not patients, but those patient records were under the ownership and direction and control of the practice, but then they brought a dentist into play who then starts seeing that patient, but whatever dealings that dentist has with those patients,
yep,
that stuff is owned by that dentist in essence. That makes me feel uncomfortable. Continue on.
It is. The more I go further, Julie, you'll be shocked. You'll be really absolutely. But our job is to unravel the surprising elements that people are not aware or probably aware, haven't taken note. So it's good to be educated. It's good to be aware. Yeah. I think that's what we're trying to help our clients.
Yeah.
The next one we are saying is that, so the cost decided as well, there were payments of hourly rates by the medical center in circumstances. When it's hourly rates, it's very clear cut that will be employees, not independent contractors. So the next key point, that's key point number 5, which is, I call it like one of the highlight of the case, the highlight of the key points, will be they have decided that all patient fees and medical rebates they were received into the bank account of the medical center. And again, with this key point, the courts have said that it's an employment and not an independent contractors relationship. How that has been decided is because, so when the dentist sees the patients and the patient pays the fees, you've got Medicare rebates, those monies usually will go into the bank account of the dental practice. Yeah?
Yes.
That's common. What the court wants to see now is those monies must go into the bank account under the name of the dentist.
That's a can of worms.
It's a nightmare because we've got a client that has 25 doctors.
Wow.
And the client was like, how do you want me to do this? What, 25 bank accounts and 25 EPOS machines?
Yeah, that's right. The complexity behind it is enormous.
It is a nightmare.
With the service and license agreement or the service and facilities agreement, my beautiful younger sister Jen has said that that's where one of the ways of doing that is that the monies go into the practice account, but 100% of that money gets paid back to the dentist, and then they pay back the services agreement amount. But that may not be acceptable either, because the money is not hitting the independent contractor's account, which is what this court decision has deemed that's an employee relationship if it's being paid to the practice account.
Exactly, spot on, Julie. So what the court is saying, I think the normal practice now, everyone is doing that, is that the bank account of the dental practice holds it, right? They will hold it. Monies go into that bank account of the dental practice, and then what they do is they will pay, so they will deduct their services fees. They will issue the invoice to the dentist, say this is 35% or whatever, 40, 45. This is the one that I'm gonna get from you. So that money is still in the bank account. They will pay themselves, and then the balance of it, say 65, will be then paid to the dentist. This is the one that the court doesn't like it. They are saying, if you say that the doctor is an independent contractor, who's having the control? The dental practice is having, because it's the bank account of the dental practice. If I have control of that business, the money should go to my bank account, the dentist account. So we have been advising a few of them. So there are 3 scenarios in this instance. There are 3 scenarios in this instance that I would elaborate. First 2 will be the most common, but I'm saying that the third one is the one we want. The first one is where the dental practice opens up their bank account, takes all the money, which I've already told you, they will issue the tax invoice to the dentist, and pays that, they keep that 35% of the service fee, 65 goes to the dentist. That's normal. That's the conventional, traditional way that everyone is doing right now. The second one is money goes to the host practice bank account. First two are not acceptable by the courts. I'm just saying it out so that I can illustrate what's happening right now and what is the normal practice of how monies are transferred. The second one is, again, bank account of the dental practice, host practice. So what happens is that the doctor actually issues tax invoice to them. Doctor say, pay me the 65. And they then pay the 65% to the doctor. Not acceptable, also not acceptable. As long as the money goes into the bank account of the dental practice, you can't. It must be to the doctors. So, how we have said previously, the dental practice is holding as an agent or on trust. As trustee for the doctors, dentists, the courts don't like it either. So what is suggested now is that the money goes into the dentist's bank account. So the dentist should set up one bank account solely for the purposes of collecting these fees. In their bank account. Then they can do two things. Because they control the bank account, the dentist controls it. He can either transfer the money out to the dental practice himself, or he can allow control and authorize the dental practice to say, you can deduct this money, do that service for me. So this is the one where this case Thomas and Ness is suggesting. It was not elaborated in the optical superstore, the Victorian one. Both cases are the same. They are saying that there is a payroll tax that the dental practice or medical practice has to pay because there's a payment. There's a payment to the doctors, even though the monies are actually the doctor's monies, because it's coming out from the bank account of the dental practice to the dentist. They don't care whether the dentists are beneficially entitled to the monies or whether the dental practice is acting as a trustee. They say as long as there's payment to the doctors, dentists, we consider that as wages, and hence you pay payroll tax.
Oh, wow.
It is astonishing. It is shocking. So if let's say, just to be a bit clearer, if the bank account was under the name of the dentist, there's no payment because the dentist has the money himself. So it's very technical, if you can see. It's very technical. I mean, to be honest, I feel that paper-wise is good, is sound. Practically,
huge dramas, practically.
Huge dramas, and our accountants are still working out with our clients. So they know what is so the clients know what to look at. The accountants are aware of this case. They just have to implement something that's pragmatic, that's practical. So they're still working out.
And I think that's been the issue. I know we've got another couple of key points for you to go through, number 6 and number 7 yet. But
two more.
This has been the issue that the conversations that I have with my sister Jen, that everyone's happy with the combined, I treat you as an employee but pay you as a contractor. Both sides seem to be really happy and satisfied with that. And the alternative to do it right to the letter of the law, neither side actually meets the requirements, the happy requirements of either side. And so it feels like there needs to be a third entity, a third relationship that needs to be brought into our system to make it work well for everybody. But go forward with number 6 and number 7.
So number 6, the courts held that this is also common. The dentists have to abide by the the doctors have to abide by the medical center's operating protocols and complete all necessary documentation for that purpose. So this is also another tricky area. Obviously, you want the dentist to adhere to your operating procedures and, your manuals and your rules and regulations. But what we are saying is that the dentist should know what to do. Like, they have to also abide by their own governing laws of, the highest duty of care or fiduciary duty, whatever. So they're already governed by law to behave in that manner, which is good. What we don't want to see is that you have your manual saying that the dentists have to adhere to our procedures A, B, C, D, E, F. So again, it's a balancing act. We also, besides us helping the clients to draft the service and license agreement, we also help the client to look at their manuals and see what's the extent of infringement, if we may call it. Like if we look at this clause in the manual that says that, oh, the doctor has to do this, then that's a control problem. Again, then
that's something that a lot of practices want to do. They want to provide a consistent service to their patients. That's part of building that trusting relationship.
Yeah.
And part of that consistency can be a raft of different things. An example would be, this is our examination routine for a new patient. We take photographs, we do this, we do that, it takes 1 hour. This is the recipe that we move through. So we do require all of our dentists to be able to move through that same process. But that's a no-go with an independent contractor.
Well, we will have to look at the manuals again, because obviously you want a systematic, uniform approach by the dentist. I mean, we all understand, like, you don't want a nightmare. The dentist doing this and the other dentist is doing something else. There's just no synchronization in that case. So it's because I think the courts were just broadly saying that, they have to abide by the medical's operating protocol. So it's really how we have just drafted it in a way that says totally in compliance with this. So, and we have to look at the manuals again, like the rules and regulations of the dental practice, what is in there. But yeah, I hear you. It is in a way, Julie, what you're saying is correct. It's a balancing act. Like I've always said, and there's just no, I wouldn't say like, you can't control them on one hand, but you still want them to have some rules and regulations so that they operate in the same SOP. I mean, you don't want one to be operating in one manner and the other dentist that's doing absolutely a different practice of, So
I imagine that's one area where if there is effective communication, it ends up being an agreement of the way we practice individuals in this practice that we all deem the appropriate and within the guidelines put out by dental associations and all the rest of it, rather than sign down the bottom here, this is exactly what you're going to be doing.
I think so. That's a good point. Yep. So that's key point number 6. Then we're moving on to key point number 7. This is the one that, Julie, you really liked in your previous podcast. So the courts held that the agreement has a restrictive covenant which would become operational upon the doctor leaving the medical center, which with such covenant to have an exclusion zone of 5 kilometers from the medical center and to be in place for 2 years after the doctor's departure. I think in your previous podcast, you say 5 years, okay, reduce it to 5 kilometers for 5 years, reduce it to 1 kilometer for 1 year. And I think the lawyer said, no, that's not good, but you can have it if you want it.
Just for the listeners who haven't listened to that episode, and the previous episode, there's a link in the show notes for that particular one. But I was fresh and naive, and it was the first dentist that I'd employed, and I went along, I skipped along to the lawyer and said, I want to organise a contract for this employee. This was back in 2003. And the norm was 5 Ks for 5 years as a restricted covenant. And he said, that will never fly. You can't do that. It's restraint of trade. And I said, what about 3 years and 3 Ks? He said, no judge is going to approve that. And I said, okay, 1 year for 1 kilometre. He goes, I'll put it in if you want me to, but it still won't fly.
Yeah. I think that's absolutely correct. So that restrictive covenant has happened during your time, is enlivened now, and is an emphasis now of the case saying that you can't do that. If you want to put a restraint on the doctor or the dentist, that's control. And when you have control, the doctors or the dentist can't be independent contractors.
So if they're an employee, then you can put down 5 Ks, 5 kilometres. But if you're an independent contractor, you cannot. But if I can extrapolate that out just one additional step, does that also mean that an independent contractor can actively contact their patients, if they were to relocate their services elsewhere and say, I am moving down the road or to the next suburb, these are my new details?
It sounds like it, isn't it? Yes, I think you can.
This is another horrifying point, Liz.
Yeah, that's the risk that the dental practice has to take. So if you can make your dentist happy, they won't go away.
Yeah.
As simple as that.
Yeah. And that's what it all comes back down to, doesn't it?
Yeah.
Try to make sure that you've got a really win-win. You're constantly striving for that win-win scenario for both you and your dentist. In inverted comma, employee dentist.
Yes.
And if they're tremendous and they're such, and we touched on this with Meghan on that last episode, and they're so crucial, or they play such an enormous role in the success of the practice, then maybe that's the time to bring them on as an actual partner within the business and step away from the independent contract employee relationship.
Absolutely. So the moment you put them in as owners, they'll be incentivized anyway. So you don't even have to worry about restraint because they're going to stay with the business. They're already part of the business. And I would say that's a clever solution, because if you put restraint, you're going to be caught under the relationship that's deemed as employment relationship. And the only way, if the dentists are so good, you don't want the dentists to go away, give them some shares. Obviously you want to retain them as part of the business. And if they become the owner, well, they will stay. They're part of it. They're incentivized to drive the business.
And there's a whole raft of other benefits that additional owners coming in, they reduces down your admin, your team management, all of you are freed up somewhat as well. It's a shared load, all the other stuff outside the clinical management, it's all a shared load. And you really are assuring the long-term viability of the practice. As we know, as dentists, just like lawyers too, you're the ones that are physically there making the money. And if anything should happen to you, God forbid, and there's no other owners there, then the viability of the business is really tenuous. But if you've got additional owners there, then it can be business as usual, even though life happens and sometimes, unfortunately, some people can't continue on with their practicing of clinical dentistry. Yeah,
that's correct. That's so true. So I think that's, I've highlighted the 7 key points. And what I wanted to say is that so they have said that these are the points that they have looked at and said that the relationship was not an independent contractor and hence subject to payroll tax. So the tribunal found that such terms and those services, the earlier 7 key points provided by the doctors, were a necessary part of the medical center business. And therefore, the doctors weren't just providing services to the patients, but also to the medical centers. So we have similar thing where the courts interpreted to say that Dr. was providing services to the dental practice. In this case, the court has said the same thing. The tribunal said the same thing and said that the doctors were also providing services to the medical centers, like promoting the interests of the medical center and blah. So look out for this one. We know that this is this point has been decided in Dr. case, is re-emphasized again in this case. So the doctors can't be providing services to the medical centers or dental practices. And the other thing they said about as well, which was important, that I need to highlight, the tribunal was satisfied that the medical centers had a medical center business rather than a purely administrative and management service business. Again, if you have a dental practice, you must make sure that your dental practice only provides administrative and management service business and no other medical dental practice business. So they were reliant. So the court then say that why they have considered the medical centers to have a medical center business and not purely administrative and management services, because the medical center or the dental practice, they were reliant upon the doctors to operate its business, and accordingly, payroll tax on any payments made by the medical centers to the doctors was upheld.
Yeah.
Payments made by medical center to the doctors who operated from the medical centers were wages. Remember, we touched upon payment from medical center for payroll tax purposes. As a result, this one, there was a quantum. Thomas and Ness was liable to a payroll tax totaling $795,292 plus penalties and interest, close to 800, so more than $500,000, close to $1 million. And we haven't calculated the penalties and interest, so interesting.
Awful. Like these 7 key points you've listed down, I've renamed them the 7 reasons why I'm happy that I don't own my own dental surgery anymore. But there must be solutions around this as well. Can I ask, do you have any clients that employ their dentists, their optometrists as employees, and they are sticking to that relationship from a legal perspective and it's working well?
We have one out of so many. We only have one. So he has kept 2 doctors as employees, but just 2. And we have already told this client that you should change them to be contractors, but he said too hard. The female doctors don't want to do it, and they have been with him for a long time. So that doesn't quite help the situation, because if he was ever audited, and then I think he's got other 7 doctors, or in 9 or 10 about that. So we already told him there's a risk that if you're ever audited, all 7 doctors might be treated as employees, and then you might be, exposing yourself to this employees' entitlements, payment, payroll tax, super and blah. But he was happy to take the risk. So it just boils down to what the parties are comfortable with already. So like for him, the good thing is he knows the position of the law, where he can then position himself and the rest of the doctors in a way where he thinks that will be good for the business. Yeah, there will be risk. It's not risk-free, but I think that's the way where he thinks that it's viable. It's a good solution, although there are risks. But at least he's aware. So all his new doctors are all coming in as independent contractors. There's none that comes in as employees.
Because coming from a history of owning my own practice for 10 years and my conversations with all the work I've done with practices one-on-one through consulting and coaching, you want that level of control of the employee relationship. And my desire, if I was to own a practice again, would be to employ my dentists it sounds like I own them as human beings, employ dentists as employees. And the hiccup around that is the remuneration, how their wages are calculated, because I'm a big believer of, and supporter of that they get a percentage of their invoices. But we do need that minimum hourly rate should they come in for staff meetings or go on holidays or have sick leave, long service leave, all those things. And it's just around getting, and as I say, there's an equation that Jenny and I have developed on an Excel document that allows for that. So just for example, you were employed as an independent contractor and you normally got 40%, then you enter that into the equation and how many days you work, on average how many hours you work, and that then extrapolates out of how much sick time that you're entitled to, holiday leave, all the rest of it, and it comes up with a fresh percentage amount. And the challenge has been to get employee dentists to really understand that, yes, you're being paid less as a percentage, but now you're being paid for holidays, sick pay, all the rest of it. So at the end of any given working year, you'll be relatively in the same financial position. However, from a dental practice perspective, we've got the control that we feel like we need to be able to provide the service that we want to our patients and etc. And you get all of the entitlements that you're due because you're an employee as well. Yeah. And that seems to be the only hiccup I've come across. Am I missing anything else? Is that the only hiccup from your end as well?
I think that's what you've said is correct. So basically, from the sounds of it, is that you are going to have an employment relationship with the dentist. So if you're happy with that, then basically you know they're going to pay all these employees entitlements, super, PAYG, pay as you go, withholding tax and all those. So you are fully aware. What is not What is not pleasant, if I may call it, or ideal, is that you want an independent contractors relationship. So that's a different ballgame from yours, but you have not structured it correctly. That has then exposed you to an employment relationship. That's the one that we want to get rid of. So if you're happy with an employment relationship, like how you have structured yours, that's fine. Control element, payment of salaries, you control them. So there's employment, there's nothing wrong with that, and you're fully aware that you're going to pay for all these taxes, super and all those.
So Liz, it's such a complex minefield of an area. What are the key takeaways our listeners should have?
Okay, so the key takeaways, they're very simple. I think they must be remembered at all times, and knowing that there's always an increased scrutiny by the regulators, SRO or ATO in this space. So the first one that we would really advise our clients to do, or anyone that is into this dental practice business, is that the service and license agreement, or just call it the agreement, must clearly state that the dental practice is not remunerating or paying the dental practitioner, dentist, or its entity for any services whatsoever. The dental practitioner is always the party paying the practice, the dental practice, for its administrative and management facility services, not the other way around. Yeah?
Right.
So it's very clear. Dental practitioner is paying, not the dental practice. The second one, it must be absolutely clear that the dental practitioners are never providing services or labor to the dental practice. We spoke about this. Can't emphasize anymore that this is very important.
It's only dental services only to patients, that's it.
That's it. Not to the dental practice. Don't be clever to invent something there and say that I want to provide services to the dental practice. It is good, beneficial, but then it will also be a downside in this instance. So what I'm saying here is that the services and labors of the dental practitioners are provided entirely to the patients, and the extent of the relationship with the dental practice is that, very clear, dental practice is only providing facilities, premises, administrative and management services. And they are being paid for these services by the dental practitioners. Point number 2, key takeaway. The third one, the income monies received, they are not the income of the dental practice, but they are the income of the dental practitioner. We all know that. I think it's quite clear. Everybody knows that. It is how the monies are handled. Yeah, we spoke about that, the bank account and the complexity about setting up this practically is not practical. But we have to do it in a way where any monies to be collected from the patients by the dental practice are to be deposited into a bank account in the name of dental practitioner. So that's the one. Unfortunately, that's how the case is decided. Unless there's another new case that comes along and say, no, this is not viable in commercial businesses. Yeah. The law will be the law.
And that decision, that was what tribunal formed that decision around that?
Oh, that was a New South Wales case, but it followed the our optical superstore, which is the federal.
Right. It was the equivalent of VCAT.
Yeah.
Exactly.
And
so if it was to go through there, you said there's a hierarchy that you could then appeal to higher courts if you wanted the stress and additional expenditure. But it's an important one if some practice out there, medical practice, dental practice, wanted to do it, because that's a key part of it. That makes it a workable or unworkable situation.
Yeah, that's so true. That's so spot on. So it is. Yeah, we haven't seen any appeal, and I think they have run out of time to appeal to the New South Wales Supreme Court. But we will see if there's, I'm not sure if there's any further appeal, they can go higher. But if there is, definitely we have another session to update you guys, which is like crucial, because you want to see whether, are the key points being turned around, it's overridden, or we just want to see what's the position at that point in time. So my ending, how should I say, my last advice probably, definitely we recommend that the dental practice review their agreements for those existing relationship in place with dental practitioners and what is currently occurring in practice, particularly with respect to the flow of monies, and obtain professional, legal, and accounting advice. I think that's just crucial.
Yeah, this is certainly an area that we need the experts.
Thanks, Julie. That was a very good point. That's the key takeaway. It's good that you know what the law has said, but you need someone to help you. Yeah, just like we know how to color our hair, but we still go to the hair salon and get the expert to do it. It won't turn out. I mean, you still can color your hair. It's still nice, but it's better when you get something like that.
That's right. But I mean, the same, we're talking to a dental audience here. That's the same. I mean, dentists are the first one to say, if I advise you to go off to a specialist patient, that's the only way that I see that you can get the best possible result here. So take the advice.
With dentists, it's kind of quite stable. We can't treat our teeth. I don't know how to do my teeth. I need expert there to help me. So they are safe. There's no option. You need to see a dentist. The second thing I would say is that dentists and dental practices should move forward in an abundance of caution and ensure that all patient fees and rebates from Medicare and health insurers should be paid to the dentist, which is the bank account that is legally and beneficially owned by the dentist, not the dental practice. So this is a complete reverse of the normal practice that we have in place at the moment.
Yeah, and because it's the complete reverse of what's happening at the moment, and some of these relationships have been established for a long, long time. And we touched on this before, we spoke about this with Meghan as well, do whatever you can to have happy working relationships. Do whatever you can to both be looking after each other's interests, so it's mutually beneficial, the relationship, and it never gets to the point, regardless of what agreement you're under or contract you're under, it never gets to the point where the lawyers are involved and the court, or should say the lawyers should be involved, but not the courts. So the lawyers are involved in creating these agreements, but the courts, let's try to do everything that we can to make sure things are happy and we don't get to that point.
Yeah.
Thank you so much, Liz. It's been enlightening.
Thank you.
It really has, and I hope it hasn't put the listeners into a state of distress for the day.
We've got a pew.
I'm always going to be looking at, because I think there has to be a way of doing it under an employment agreement that will work very well and be legal as well. So I'm on the case constantly trying to find that out. I think I've got to start going to other health modalities and finding what they do.
Definitely. It will be, that's the spotlight. People will want to know, because, it has to be practical, in the common practice of the business. It has to run in that manner where it's practical to them. But at the same time, you have to run it within the legal parameters. So I'm sure there should be an alignment anyway.
Yeah, there should be. There should be. Well, here's to all of us pushing forward to an alignment and happy working relationships moving forward. I thank you so much, Liz. And if there are any updates, we would appreciate so much you coming back on and letting us know what they are.
Thank you, Julie.
Hey, if you enjoyed listening to this episode, you should join the club. The club members receive an online lunch and learn twice a month, where I share insights, systems and strategies to improve the success of your practice. These lunch and learns could not be easier to train your dental team. They are recordings, so you can watch them at a time that suits you. For example, during team lunchtimes, pay your team members for their lunch hour. The first half hour, they're eating and watching the presentation. The second half hour, they're discussing how to implement this particular insight into your dental practice operations. The club members also enjoy live access via online sessions twice a month with me, where we discuss all the many things that you can do to have a more productive, more efficient, and happier work environment. These live sessions are powerful, and members enjoy bouncing ideas off each other and sharing resources and advice. And remember my favourite quote, it's by Archilochus, and he states, "We do not rise to the level of our expectations, but fall to the level of our training." So join the club now and start upskilling your team members and improving the operations of your dental practice. I hope to see you there.